The following program is made possible in part by the Dayton Bar Association.
Good evening. My name is Jeff Swillinger, and welcome to You and the Law. This month's installment is focusing on bankruptcy law. Our guest tonight will speak from the perspective of the debtor's attorney. We will also spend some time on student loan debt. Those of you who are watching the show are probably familiar with how to find us, our website for Dayton Access TV, DATV.org. There will be information on the website about past shows. There will be information about this show and how it can be found on various stations throughout the greater Dayton area. Now, with that in mind, I welcome you again and turn to our guest. This evening, I'd like to introduce Wayne Novick. Wayne is a very experienced attorney. He has practiced law in the greater Dayton area for over 30 years, focusing on the rights of debtors. We will get a bit of a panoply of information on different subjects during the next hour, and I hope that you'll call in with questions. This is a live show. I don't know whether this month our live streaming is on or not, but it will then be we'll go to YouTube after the show this evening and be on later this week on YouTube for you to watch, and hopefully refer your friends to take a look at also. Well, Wayne, good evening and welcome.
Good evening, Jeff, and thank you very much for inviting me to spend the evening with you and try to answer people's questions and do a little bit of education to the public on what bankruptcy is like, and then maybe we get around to some student loans and hopefully direct people in some good direction. You know, I've been doing this, actually it's almost closer to 40 years, I can't believe that either, and it's an interesting profession. I get to sit and meet people every day, sit like this, and have to deal with people's questions. And people go, why do you like to show up at work all the time? And I go, well, I'm kind of like a cross between Oprah and Dr. Phil. You're going to explain what's going on, and I'm hopefully able to give you some sort of suggestion. And most of the people we deal with are in some sort of financial trouble. Hopefully they get to us earlier than later, and that's really important. If you're starting to feel that you've got a lot of issues coming up with your finances, whether it's due to a job loss, whether it's due to a divorce, whether you've got lots of medical bills or an accident occurred, and you're struggling, often it pays to go out and see a lawyer like me who can give you a consultation. And most situations and most consumer bankruptcy attorneys will speak to you for a free consultation. They'll spend 20 minutes to an hour going over your situation and hopefully give you some ideas and explain some of your rights. And we're going to try to do a little bit of that tonight. And people come into my office and, you know, they're looking for what the bankruptcy code calls a fresh start. It's not what we're going to leave you with nothing. The law is going to allow you to keep most of your household goods. It's going to allow you to keep a car if you're not behind or it's not worth too much money. You're going to be able to hold on to your house because Ohio has some really good exemptions. And we're going to talk about that as we move on. So bankruptcy is to give you a fresh start. Some creditors think we're trying to get you a head start, to get you way ahead of them. That's not the goal. The goal is to be a fair system, which the bankruptcy is. And people know that there's different types of bankruptcy. And what we like to talk about is Chapter 7, Chapter 13, and sometimes a little bit about Chapter 11. And those are all technical terms coming from the Bankruptcy Code. But in simple fashion, that's what we're looking at. Chapter 11, it's primarily for corporations trying to reorganize themselves. It's not really for someone like me or an individual. They're complicated, they're expensive. That's what Delta filed, that's what General Motors filed, that's what Delphi filed. But if you've got a small business and it's got some hope, then there's a bankruptcy lawyer that you should be able to talk to see what the chances are of reorganizing and maybe keeping that business going. Most of the people I deal with are consumers. And what they're trying to determine is whether they should file a Chapter 7 or a Chapter 13. And Chapter 7 is what most people are trying to file. It used to be called liquidation. And that has a scary connotation because people think the bankruptcy court's going to come take everything. Doesn't happen. Most of the cases, nothing is taken. You hang on to almost everything that you have. Sure, you're driving a $20,000 car and you don't owe any money on it, you're not going to get to keep that in a Chapter 7. But Ohio has what we call exemptions, and exemptions protect your assets. Bankruptcy is federal law, but we turn to Ohio to protect our stuff. And Ohio changed their exemptions in 2013 because Kentucky changed them 2 years earlier. And you know Ohio is not going to let Kentucky treat their citizens better. So Ohio did some really nice things in 2013. The exemptions went up in 2016, and they're going to go up again April 1st, 2019. And the more they go up, the more you get to keep. As an example, you get to protect of equity in a car of almost $4,000. You get to protect almost $136,700 of equity in the house you're living with, and so does your spouse. So that's a pretty good protection. That means most people are able to keep their house in a Chapter 7 as long as they are current. If you're behind, different story. So in Chapter 7, we're looking at the type of debts that you have, whether you qualify income-wise, and what happens to that debt, what happens to your assets. And generally, as we said already, you're going to get to keep most of your assets. And if not, it takes a little bit of planning to make sure you're there. So in a Chapter 7, we look at different type of debts. Excuse me a moment, I sometimes talk so fast I dry myself out. But
Go ahead, take your time.
Anyway, in a Chapter 7, you have to qualify income-wise. And it sounds like a lot, but we talk about means testing. So to qualify simply, a household of two has to be making less than $61,000. If you make a little bit more than that, bigger test to take, something that you need to talk to your lawyer about. And so then in a Chapter 7, once you qualify income-wise, now we're going to take a look at what do you own and how do you protect it. And we're looking at what's the stuff where your household goods are worth, how much money you have in your bank, your retirement accounts are protected, most of your life insurance is protected. It's very rare that I find anybody losing household goods. There are exceptions. I had a gentleman once who had toy soldiers, and I said, how many toy soldiers? It turned out he had $20,000 worth of toy soldiers. He didn't get to keep all of that to file bankruptcy. So that's an issue there. And what's been coming up as an interesting issue, and I saw you had a topic in You and the Law previously about guns. And nobody in the bankruptcy court is coming to take your guns, but guns have cash value. Correct. So you can only protect so much value in your guns. If you have a lot of guns, you want to keep them, you may not be able to file Chapter 7, or you might have to pay the courts some money to hang on to them.
While you're talking about values, will you comment on when you have to have an appraisal? Because I suspect that some of your clients or future clients might come in and have one idea of what the value of a certain property is. There has to be some standard by which they have to go, I guess, ultimately for the court. Is that right?
That is correct. And normally when we look at your household goods, what we're looking at is not what it's going to cost you to replace that item. So that big 50-inch television set that you bought for $1,000 3 years ago probably doesn't have a whole lot of value anymore. Maybe you can't get Netflix on it. Maybe it doesn't connect to the internet. Maybe it's not 4K. So we're really looking at what I would pay you for your used television set, or sometimes what we say, what would I get if I had it at a garage sale? Automobiles, a little bit different. You know, you could look at NADA or KBB, or sometimes we have an appraiser in town who will appraise the car for what its willing seller, willing buyer value, not what you would get at trading the car in, but then again, not what I would pay for it off a used car lot.
Since you mentioned guns, what about guns? I would think
How do you
people-
value them?
How do you value them?
And that's a good question. If I have somebody with a lot of guns, I might tell them to go get it appraised. Take it to the shop that you bought them at. Get me to write an appraisal. We have that with coin collections. We have that with jewelry. What is jewelry worth? I don't know. I can't tell one piece from another. But we send somebody to a jeweler. Or we might send somebody over to a pawn shop to find out what the value of something is. So we can determine what these values are to get an idea, because we should know that this piece of property is not at risk, and if it's at risk, you understand what the risk is. After we've determined what you get to keep, now we're going to look at what happens to your debts. And there's different types of debts. We have secured debt. That'd be your car, your house, possibly the furniture loan that you've gone out and taken, maybe some rent-to-owns, okay? Things, the computer you might have bought might be a secured debt. And so with secured debt in a bankruptcy, we're going to determine A, if you're current, you can keep it, and B, whether you want to keep it. So if you're current, then you have an option of keeping that item and paying for it. You don't get it for free. So I have a car, I've been making my car payments, there isn't very much equity in it. The creditor's going to let me keep the car, but I'm going to have to continue to pay for it. I also have the option to say, I don't want that car anymore. Just let it go. And back it goes. And so that creditor has their collateral, they sell it, and the balance of that debt will be discharged in the bankruptcy. So same with my house. If I'm current in my house and I don't have more than $136,700 worth of equity, I can keep it, but I have to keep paying for it. I also have the right to surrender it or give it up. So those are choices with secured debt. There is also unsecured debt. Unsecured debts, credit cards, medical bills, utilities, anything that doesn't have collateral on it. And most unsecured debt is discharged. There is some exceptions to that. You know, if you committed fraud in getting it, filled out your credit application and made stuff up, you lied to obtain the property, those are exceptions to that.
What about charges in contemplation of filing bankruptcy?
So you shouldn't do that. And the code builds in some specific numbers and some time frames. And a creditor has a right to look at that. So if you're going to charge more than $750 in the 75 days prior to your bankruptcy, the creditor has a right to object, and that portion of that debt probably isn't going to be discharged. So not a good idea. Sometimes you have to make those payments for a while to get over that presumption. If you charge a huge amount, the creditor has a right to object to that, okay? There are other exceptions. Certain type of debts are not dischargeable. The main one is taxes. If you owe taxes, you're probably still going to go owe them after the bankruptcy.
Federal, state, and local.
Federal, state, and local. There are some exceptions to that, which is something you should talk to a lawyer about. If your taxes are more than 3 years old, and they're for income tax, and you filed timely, either by the April 15th or your October 15th extension time, you may be able to get rid of those taxes without calling the guys on the radio. And so taxes are an exception. Child support, alimony, they are exceptions. The Bankruptcy Code changes of 2006 created a whole new category called domestic support obligations. In short form, that's pretty much anything inside your divorce decree that you're supposed to do. So if you're in that situation, that needs to be reviewed by your bankruptcy attorney.
You're supposed to keep life insurance on your children or on your ex-spouse, according to your separation agreement. That's the kind of thing that may fall under the non,
That would kind of fall under domestic support.
non-dischargeable.
It's possible. A lot of times what you're seeing in the divorce scenario is one spouse is supposed to pay the other spouse some money and refuses to do so as part of a property settlement, and then would run to bankruptcy court and try to discharge that. Not going to happen in a Chapter 7. Or one spouse is supposed to pay all the credit card debt, and the debt is joint, both parties are liable, and the spouse says, I'm going to take all this debt, and then I'm going to run over to a bankruptcy lawyer and wipe it out, and then they're going to go after my spouse. Not going to work. That's not going to be dischargeable in a Chapter 7. So those are some issues, and when you have bankruptcy and you have another legal thing, best thing you can do, talk to a bankruptcy lawyer. It's very, very important. One of the things that goes around is bankruptcy controls everything. So you're in the middle of a divorce, one of the parties files bankruptcy, that divorce is on hold. You're being sued, one of the parties files a bankruptcy, that lawsuit is on hold. I'm suing somebody, and then I file bankruptcy, that puts that lawsuit on hold. So bankruptcy freezes all that, and you've got to go back to the bankruptcy court to get permission. So somebody files a bankruptcy to stop that divorce, run to the bankruptcy court says, oh, we just wanted to know about this divorce going on. You now have permission to go forward, but before you've done, come back and see me so we can see what's going on with the assets that are being transferred. Okay? The other big issue, one we'll talk about a little bit more, student loans. It's very, very difficult to discharge, wipe out a student loan in bankruptcy even today. It's a very complicated situation. It very rarely happens, especially in this part of Ohio. We're not having very much success getting the courts to discharge it. There's an old student loan case. It's from the 1980s called Bruner. And Bruner sets what they called hardship. And if you can't prove that hardship, you're not going to get a discharge of your student loans. It's under scrutiny. It's under attack throughout the country. Lawyers are trying to overturn that. And the Department of Education last April asked for people to try to help them redefine hardship. National Association of Consumer Bankruptcy Attorneys, of which I'm a member, we wrote a whole bunch of stuff asking them to reconsider and to allow the bankruptcy court to step in. So far, we've heard nothing.
So this raises a question. I remember as a young lawyer, I did some domestic relations law, and back then the laws were much different, and at times someone would come to me and say, this is what I want, and this is what I want to pay, if I'm going to pay alimony or child support, as they were called then. But then they found out they were going to have to pay more, and they said, well, that's more than my friend, and my friend's situation is the same as mine. Well, in this context, it seems to me from what you said that people can't rely on the law in this part of Ohio, for instance, in all situations to be the same as the law in northern Ohio or possibly in Kentucky on certain subjects.
That is true, I think you'll find in a lot of the areas of the law. The law is written.
Right.
It's in black and white, but it's subject to the interpretations of lawyers, judges, hired judges, so yeah, that's what we lawyers do, right? We try to interpret what is there. But in that situation, the application, as we were discussing, of the Bruner test is pretty strict in the Sixth Circuit at this point in time. There are exceptions, and lawyers are challenging them. But it might be a little bit different if we went out of this local area. In the First Circuit, they use more of a balancing test. And the circuits I'm referring to is different parts of the federal court system. And so until such point as the Supreme Court balances all the circuits, we can't have differences of opinion.
Well, this is like we default back throughout this conversation, it seems to me, to people aren't necessarily going to have these questions until you advise them a bit, but they need that consultation to understand that what may be their situation is different than somebody else's. And they have to adjust their expectations a bit based upon what information you provide to them and what their circumstances dictate. Is that fair?
Yeah, that is fair, because just because two people come to see me about filing bankruptcy, and one may be able to file a Chapter 7 and one may not, but yet they go, my friend filed, he filed. And I said, you may not know the whole situation, right? And so you must, it's good to talk to people and get a basic, but if you're in this type of situation, call a lawyer. Spend the time with a consumer bankruptcy lawyer so that you have somebody that understands that. And there's good resources. You can always call the Dayton Bar Association, and they can refer you to some people that are practicing primarily in bankruptcy. You can also contact the National Association of Consumer Bankruptcy Lawyers. That's always a good thing to see, because those are lawyers who are spending extra time to get educated nationally on this subject matter. So that's always a good thing to say. American Bankruptcy Institution is another organization that helps do that. And it's something when you're checking your lawyer out that you can ask. You can also look up on the Google machine that is out there.
Okay, two quick questions relative to that, or one question. This would be a good time to say to our viewers that the Dayton Bar Association underwrites this program. The Dayton Bar Association, amongst the many services it provides, take a look at your screen. It provides a lawyer referral service, 937-222-6102, and that's where you might be directed to an attorney who might be able to assist you with your questions and with a potential bankruptcy filing. The second part I wanted to mention in that regard is, and again, we started on Chapter 7 here, and I don't want to interrupt too much the flow of things, but at some point I want to talk about credit counseling and the initial decision as to whether you go to a credit counselor or to an attorney. We'll just put that in at the appropriate time, and people will also talk about fees that people might expect generally. How are fees charged? Is there a fee for an initial consultation? Things of that nature. Just want to put that out there.
Sure, we'll get to all of that. Let's we've talked a little bit right now about Chapter 7,
Okay.
and we're going to shift a little bit, but generally Chapter 7 is available if you're income qualified. Maybe you don't have a lot of secured debt. There's no equity in your secured debt. You have a lot of unsecured debt, and maybe that's a good way to discharge all that unsecured debt, get your fresh start, can keep your car, pay for that. If you're current on your house, pay for that. Chapter 13 is kind of like Chapter 11, but for the little guy. There are limits to how much debt you can have, currently just under $400,000 in unsecured debt, and I think it's $1.3 million in secured debt. Sounds like a lot, but that's basically debt that would be mortgages and things of that nature. And why do people file Chapter 13 as opposed to filing Chapter 7? The first reason is they may make too much money to get into a Chapter 7. And again, in 2006, when the bankruptcy code changed, they put a means test, a black and white test pretty much, to say if your income is above this, you're not filing Chapter 7, go file Chapter 13. 2, if you are behind on your car and you need to keep it, or your house is in foreclosure, odds are filing Chapter 7, that's not going to help you stay in your house, and it's not going to let you keep your car. But in Chapter 13, we can work out a plan in which you're paying the bankruptcy court, and the bankruptcy court is helping get your car payment caught up and stopping that repossession, or it's stopping that foreclosure and helping you have time to catch up that arrears. Because in a typical Chapter 13, where you may be $8,000 or $9,000 behind on your house, and the mortgage company's saying, well, we'll give you 3 months to catch that up, and you can't do that. But in Chapter 13, you're going to get 60 months to catch that up, spread out. So that may allow you to have enough time to keep the payment affordable that you can now save your home. So Chapter 13 allows that to happen. You also may file Chapter 13 to manage tax debt, and you may file Chapter 13 to manage student loans. There's ways to hide from the student loan collectors in Chapter 13. And you may file Chapter 13. I know this, sometimes people don't necessarily see that, but some people want to pay all their creditors back. They just can't do it with the interest. So they choose to file Chapter 13 and make payments to the court, and the court pays their creditors, maybe not completely in full, but to the best of their ability to do so. And finally, you may be in that situation where you have that gun collection or that valuable toy soldier collection, which is what my client did, and went into a Chapter 13 and paid that $20,000 out over 5 years to his creditors. He got to keep his toys. So it was a win-win for all the parties involved. Chapter 13 does involve a commitment, because you're now going to make payments to the bankruptcy court, generally by a wage deduction, every pay period, or once a month. And the bankruptcy court's going to collect that money and pay it out to your creditors. So there are reasons to go into Chapter 13. Some of them are really, really good. And there are reasons to be into Chapter 7. Those are the type of valuations that you have to make when you come see a lawyer. And the lawyer can help explain your options in details as it applies in your case, not necessarily in that other person's case. And it lets you know what the lawyer may let you know, I think this is your better option, but these are your options, make your choice. And in that choice, you can add in the option of credit counseling. Now, it's interesting to note, as we slide to this for a moment, in 2006, they made credit counseling mandatory before you can file a consumer bankruptcy case. And the bankruptcy laws were, creditors were paying a lot of money to have Congress change the bankruptcy laws, and in 2006 they did. Actually, it was 2005, but mostly it went into effect 2005, October. And one of those was the creditors were convinced that if you took a credit counseling course, 95% of the people would not need bankruptcy. They would all be able to go do credit counseling. Well, after several years of surveys, they found the 95% number was right, except it was 95% of the people that made it to the pre-bankruptcy credit counseling belonged in bankruptcy. They were close. They had the right idea, they just had the wrong conclusion. We are fortunate in the Miami Valley to have an organization through Lutheran Social Services called GraceWorks. And they are a credit counseling service. I have sent numerous people to them in the past because sometimes credit counseling may be the option the individuals prefer, or it may be their best option. So sometimes it's okay to talk to the bankruptcy lawyer and learn what Chapter 7 is and Chapter 13 and whether it's in your best interest. And sometimes you may just be better off with credit counseling. And sometimes that's a good starting point. You'll go down there.
You'll go there first.
You could go there first. And I can say over the years that GraceWorks here, they will tell you if they can't help you. And they will tell you to go see a bankruptcy lawyer. Now, you got to be really careful. There's a lot of credit counseling companies that advertise on the internet, and there's a lot of credit counseling companies that advertise late-night television and on the radio. And there's another item called debt management, and you need to be really careful with those. Do some research. Some of those credit counseling companies are good. Some of them are not, and be very, very leery of debt management services. You can look through it out on the internet. Debt management basically means you pay some company money every month, they hold it until they get enough money to settle. Meanwhile, your creditors aren't getting paid. Sometimes you're getting sued, and they're not doing anything to stop that. So you got to be really careful. A lot of debt management companies have been investigated and put out of business. So be careful. The Ohio Attorney General's website has a lot of information about debt management companies. So it's a place to take a look at. So yes, that's a good option. And in each individual's case,
The credit counseling.
credit counseling, bankruptcy lawyer, those may be options that you need to find out about to see how they apply in your situation, which is maybe different than somebody else's situation.
Okay.
So your question before, as we move along here, was what do bankruptcy lawyers charge for their consultations to come in? And I can only give you an idea what generally is happening in the community because every bankruptcy lawyer is a little bit different. But most consumer bankruptcy attorneys, for most consumer cases, will not charge a consultation fee. And so
An initial consultation.
initial consultation fee. And what's defined inside that initial consultation fee, of course, is with that attorney. My office, we often spend an hour, sometimes a little bit more. We ask you to bring us stuff. So we're just not talking like I am tonight in general terms. I want to relate the bankruptcy to your experience. So we ask you to bring bills and credit reports and tax returns and pay stubs. So we're gonna give you a good quick review, and then we're gonna tell you what else we're gonna need to proceed forward. And sometimes we can tell in that 30 to 45 minutes, you're not filing Chapter 7, you're not filing Chapter 13. Or this is your best, this is what looks like your best, you gotta come back with some more information so we can fine tune it. So, but a business case, a small business case, or even a failed business case, most lawyers charge a consultation fee for those, depending on the complications involved. And there are consumer-type cases where there might be an involved divorce, or there might be other issues where a consultation fee. But the typical consumer, I wouldn't even just say in this area, but pretty much through the country, there's no consultation fee.
After the consultation fee, and let's assume someone chooses to go forward with the bankruptcy, whether it's 7 or 13, do individuals, corporations, do they pay by the hour? Do they pay a contingency fee? Do they pay their fees on some other basis? Can you just talk briefly about that?
Sure. Again, in most consumer cases, and when I use the term consumer cases, I'm talking about generally somebody that does not have a business or has not had a business, is not involved with an LLC or any type of corporation, just a typical wage earner that's out there. Generally, the fees are controlled by the bankruptcy court. Every bankruptcy lawyer's fees is subject to approval by the court. And there's a filing fee. So a Chapter 7 filing fee is $335. Chapter 13 is $310. You have to do pre-bankruptcy education, and those fees range anywhere from $10 to $50, depending on the provider that the lawyer is using or referring you to. You have to take.
Required by the court.
It's absolutely mandatory. You cannot file a bankruptcy. And there are companies that'll help you sort of pro se, file by yourself a bankruptcy. And it's really sad when they get down there and find out that their bankruptcy doesn't count because they haven't taken the pre-bankruptcy required credit counseling course. It is just, there's no excuse. There's no waiver of it. You have to take it. So those are required out-of-pocket expenses. Bankruptcy fees in this area, in the consumer case, are almost always flat fee. There are some exceptions in the more complicated cases. And in a Chapter 7, that's what we're referring to, they're a flat fee. I would say they range anywhere from $1,000 to $1,500 or $1,600 plus the associated fees, depending on the complexity of the case, depending on the lawyer that's handling it. So there's some range in there. Another reason to speak to an attorney to get comfortable and learn what your fees are. We don't usually quote fees over the phone because I want to meet you and I want to know about your situation. You know, you might not have a whole lot and maybe you're not going to get charged the higher end fee. You might be only on Social Security and it's not as complex. So there are differences involved in that. Chapter 13 is a whole different story. Filing fee is $310. You still have to do that pre-bankruptcy credit counseling. And the bankruptcy court has what they call a no-look fee. Almost every bankruptcy court in the country has their own version. And that's a part of the fee that has preset services included in it. And in Southern District of Ohio, Dayton, Cincinnati, Columbus, the no-look fee is $3,700. Some lawyers take all of that up front. Some take none of that up front. Some take some combination. The rest of it is paid as the debtor, the party in the bankruptcy, pays the court. The court then pays the attorney out of the monies that are collected. There are lawyers that do Chapter 13s that refuse to take the no-look fee because they don't feel it justifies in a particular case. They then have to make an application to have their fee approved by the bankruptcy court based on an hourly rate. More complicated bankruptcies are basically on hourly rates. So,
Okay. All right.
and then there are additional charges sometimes in a Chapter 13.
I was going to ask that because you mentioned about paying your money into the court and having the court manage your payments to your creditors. So I thought there might be some charges associated with that.
The court gets an administrative fee.
Okay.
Currently in Dayton, it is 6.5% of every dollar they collect. I think Cincinnati is 5 and change, and Columbus is somewhere in between the two. And that depends on volume of cases, administration costs, and things of that nature. Okay, so that is also based in there. So we've talked a bit about the term discharge.
Yes.
And, that's what you're trying to get in a bankruptcy. What really is it? Well, the discharge it's not a pencil eraser. It doesn't run down to your credit report and erase everything on there, nor does it go to your creditors and erase that. It's actually a court order that's really an injunction preventing the creditors from collecting from you. But that's not how we all refer to it. We really just refer it as, yep, you got your discharge and all the debts that can be discharged are now wiped out. So you file a Chapter 7 and all your credit cards are discharged. Your taxes, probably not discharged. Your secured debt, it's not really discharged. You're going to continue to pay if you wish to keep it. But if I gave up that car and I gave up that house, that underlying debt after the collateral is sold is also discharged. So that's what you're seeking for. And the same thing happens in your Chapter 13 when you finish it, 3 to 5 years down the road. Now you're going to get your discharge and move to your fresh start. Chapter 7, you're usually 6 months. From filing of the case to the time you get your discharge is a little less than 6 months. So that is one reason why people want to get into Chapter 7 so that they can start to rebuild. Maybe then go out, get a house or get a car eventually down the road and look to the future of that.
When we're talking about that, and maybe we'll get into that in a few minutes, looks like we have about 17 or 18 minutes left
Okay.
in the program. I was wondering if we could address a little bit about what people are paying during that discharge period, what they have to hold on to, such as taxes, and what happens if they continue not to make their tax payments.
Okay,
and
so
this type of thing.
Yeah, and this is important. Sometimes people I speak to people, and they file a Chapter 7, and they get the impression, okay, I'm in this. I don't have to make my car payment. I don't have to make my house payment. Well, that's true if you're not keeping it, but if you're keeping your car and your house payment, you're going to continue to make those payments. Otherwise, as soon as you get your discharge, they're going to repossess your car, and they'll go back and foreclose on your house. If I owe taxes, you're probably not making payments during the pendency of the bankruptcy in a Chapter 7 because the IRS is going to just put everything in abeyance until your case is over. And about 30 days after you receive your discharge, it's time to reconnect with Uncle Sam or state of Ohio or your local municipality and get a payment plan going. And then you got to stick to that payment plan because those taxes won't go away. In a Chapter 13, those taxes are going to get paid. They probably are going to get paid in full. There are some exceptions to that in special cases, but part of your Chapter 13 plan is going to include car payment, house payment, tax payment, some percentage to the unsecured creditors. Okay? And when it's over, you probably still have a house payment because most of us end up with 30-year house payments, so a 5-year Chapter 13 isn't going to make it go away. You'll just revert back to making that payment. So I'd like to take a moment or two to kind of scoot over, since we're down to about 15 minutes or so, talk a little bit about student loans, if that's possible. Let's go over to that. Unless you had another question.
One quick
Yeah.
question about once you have been discharged in bankruptcy, either Chapter 7 or Chapter 13, the answer to this may not be the same, depending on which path you go down. But how long, I've had people say, well, how long does this stay on my credit report? How long will this bar me from being able to obtain credit?
Okay, two completely unrelated answers in essence.
Between
Okay?
7s and 13s,
No.
between those two last points.
No, between your question about how long does it sit on my
Good.
credit report and whether or not I can go out and buy a car tomorrow.
Well, if you
So
work
those
out
are, yeah, there's a big difference. So, and there's a difference in Chapter 13 too, in Chapter 7. So Chapter 7, generally, if you're working and have a job and you file a Chapter 7, you could probably get a car 48 hours later in that time period. There are companies, there's actually one of the largest companies in the country actually was started in Cincinnati, selling cars to people who filed Chapter 7s. And it's based on whether or not you're working. And it's based on whether or not you can afford the payment. And they'll sell people low mileage, relatively new cars, trying to keep their monthly payments down, but you're going to pay an interest rate of 20 to 25% or more. And there's now 5 or 6 different companies that I get mail from every day in my mail trying to sell my clients a car. House, a little bit different. Right now, the government is working on a last bad act for most of the lending in the mortgage world. And your last bad act could be the discharge in your bankruptcy. It could be you surrendered a house, got a discharge in bankruptcy, and then the foreclosure finished up. So that last bad act starts a counting period. And right now, the last bad act is 2 years. So if you get a bankruptcy discharge in March of 2019, you're probably not going to be able to go out and buy a house till a minimum of April 2021. So that's kind of what's there. That's not what's on your credit report. It can stay on your credit report for 7 years, okay? And but it's always important after your bankruptcy to look at your credit report and keep an eye on it because some things are misreported. It's just the nature of it is. And there's a ways to fix that and something your lawyer can always tell you of how to look at your credit report, where to go, and what to do with that.
Excellent. One last point that we had on our outline here, Social Security, and the impact of filing either a 7 or a 13 on your Social Security.
None. Okay? What is important to note in any situation you are, especially for an older person, is your Social Security is pretty much exempt from collection for most of your creditors. You got credit card debt and your only income is Social Security? Oh well. They cannot garnish it. They cannot take it out of your bank account. The only people that can get to your Social Security is if you owe the government, you owe governmental student loans, not private student loans, you owe the IRS. Generally, if you owe the IRS or a government agency, you can get a payment plan, or or they're limited to 15% above 750 to collect. So you got a $1,000 Social Security check, you owe a government student loan, they can get 15% of $250 a month. That's how the Social Security works. It's important if you're in financial stuff, in difficulties, and you have Social Security and then maybe working part-time, keep your money separate. Keep the Social Security in its own bank account and spend the money that you're earning first. That way that Social Security is protected from your creditors.
On that important point, let's then move over to student loans.
Okay, so the world today, there's lots and lots of us out there that either are on have old student loans, know somebody that owes student loans, or having difficulty paying their student loans. And you have to distinguish between private student loans and government student loans. And in the world of bankruptcy, not a whole lot of difference. Most of the time, if you owe a private student loan or a government student loan, you're still going to have to pay it. You're not going to be able to discharge it. But there are differences. Government student loans, you can go to the National Student Loan Data Center website. You can look up your account, and you can see what loans are in there. If there's a loan in the National Student Loan Data Center, it's a government loan. If you don't have a cosigner, it's probably a government loan, unless it's a really old loan. Old loans may still have cosigners on it. So government loans, they have programs. And you can go to either the servicer that's working on that, you can go to the Consumer Financial Protection Bureau website, National Consumer Law Center, you can talk to the servicers, you can probably get your student loans put into an income-driven repayment plan based on your income. Don't ignore student loans. Talk to the servicer. Come see a lawyer that works with student loans who can at least help you figure out what your payments can be if it's something that you can afford, or explain some other options.
Be it a private student loan or a government.
See a lawyer.
Back loan.
Okay? The private student loans don't necessarily have payment plans available, but a lot of times you can work with them to get there. But most of the time when I'm seeing people coming into my office with student loan problems, especially private student loans, they've been sued. They adopted the ostrich defense and put their head in the sand and didn't do anything. And now that private student loan is garnishing their wages. Now that's handicapped a lot of the things that you can do. But if you know those loans are out there and you're having difficulty paying, you need to address that.
And in that last scenario, are interest and penalties accruing over the time that these loans are now being garnished?
Okay, yes.
Or excuse me, your accounts are being garnished to pay the loans?
Okay, so,
Not sick.
yes, there is still interest on private student loans as they go. Government can garnish you, but you really got to get in serious trouble to get to that point. Do realize that if you're with a government loan and you're choosing between deferment, not making any payment, or income-driven repayment, deferment's not working towards getting rid of that loan. Income-driven repayment, if you stay on the program for 20 years and make your payments, the balance is gone. At least that's the way it's set up today. Both of those things are dangerous because they have negative amortization. You're paying less than what the interest rate is. If you're deferring, interest is accruing. So you got to watch out for that and be careful. I've had some clients come in who are going to start making lots of money in a couple of years, and it's like you're going to just pile the interest up. So you have to watch out for that. There are other things out there. You know, some teachers are eligible for teacher service forgiveness. Some people in public service are eligible for public service forgiveness of their government loans, not private loans.
Now, are we talking, again, federal, state, and local, or just federal, or just state, when it comes to the forgiveness policies?
It's federal.
Federal.
It's federal and has to do with federal student loans.
Okay.
Okay, and government-backed federal student loans.
Okay.
And if you're on disability, Social Security disability, and you can't make your payments, There are forms to fill out. If you're on permanent Social Security disability, you can get rid of that student loan. So there are options there. The biggest problem is people fear them and don't seek help. And that's not the way to address with those. So we've done a lot of work with private student loans and are able to do some settlements with them where people are paying 40 cents on the dollar to get rid of the loans. But you have to get in there early enough to deal with them.
Does it depend on when the loan was incurred? If you incurred the loan 20 years ago as opposed to a year ago, and not the same individual per se, but let's suppose the person 20 years ago had a government-backed student loan.
They're still going to end up paying their government-backed student loan.
Okay.
Still there.
Okay, by new rules, subsequent rules, or by the rules of that period of time?
Right, what's going on right now.
Okay.
That's how that works. Private student loans may be a little bit different. If there was a private student loan that was now 10 years old.
Now, are we talking about bank loans? as a
Primarily
general
what
rule?
happened, yeah. So let me go back a little bit because
Yeah.
we got sidetracked a little bit.
Okay.
So the bankruptcy code determined that all student loans at a point would be not discharged in bankruptcy. And the bank said, whoopee, we can now lend this money and never worry about somebody wiping it out. And so the private banking industry then just went full bore into lending people money because they knew these loans were great. You can't discharge them in bankruptcy. Credit cards, they can be discharged, but not these student loans. So private student loans, there may be other defenses which are not available to government student loans. So a private student loan may have a statute of limitation collection issue. So if you haven't made any payments and it's been long enough to meet the statute of limitations issue, you may be able to wipe that debt out in state court. So a lot of the battles in private student loans take place in state court. There have been some cases filed in Ohio because the student loans are being collected in Pennsylvania, and the Pennsylvania statute of limitations is 4 years. So it's right now being litigated. I have one pending in front of the judges. So we're doing good.
Yeah, we're doing good, yeah. Okay, okay. Does the term government-backed student loan, is that a term of art, or does that have meaning when we're talking about private versus government loans? Is a private loan ever government-backed? Is there only one type of government-backed, and that's the one that's a government loan?
They're all government loans at this moment.
I've heard these
Yeah, the expression
terms.
the term basically has gotten misused.
Okay, that's why I'm asking.
Yeah, so our distinguishment pretty much is if the government has lent it to you, you'll see it in the directory. And that is usually direct loans, Stafford loans, Parent Plus loans, things of that nature. Those are pretty much it. But you go in that directory, sign in at the National Student Loan Data Center, you'll find all your government loans are there, who's servicing them, when you took them out, and the documents to go with it. If they're not in there, they're probably a private loan. If you go to your credit report, and the easiest way to get a free credit report is by going to annualcreditreport.com. Annualcreditreport.com allows you to pull one credit report from each credit agency once a year. If you space it out every 4 months, you now have 3 credit reports for free in detail, and you'll be able to see if there's a student loan in there, it's probably there. The biggest private student loan problem lender or collector at this moment is National Collegiate Student Loan Trust, and they're all over Ohio, and they are constantly suing people, and their whole system is to try to get default judgments and proceed forward. They don't like when lawyers get involved to try to deal with them. So if you get sued, get help. Don't wait. It's really frightening to see that happen to people.
You know, I think many of us would just take it for granted that we're talking about college loans, okay, when we say student loans. But what does this term encompass? Might it be, well, we've got a little less than 2 minutes, so just quickly, what,
Well,
junior
generally,
college, four-year college, private, what about prep school, high school?
if there's a loan made out for an education purpose under the bankruptcy code, that's a student loan, basically. So if the bank was to lend you a private student loan to attend prep school and you as a parent signed for it, you're probably on the hook.
But-
Now, your child can't sign for it, right, because they're a minor and underage.
But the rules that apply to junior colleges or four-year institutions, those would apply there.
Correct.
Under federal law. What about for-profit versus non-for-profit institutions?
No difference.
No difference, okay.
Okay, now, there are several for-profit colleges that have run afoul of government regulations. ITT is one, Corinthians College, and the government has been working with those people who owe that money to discharge those.
Okay. Well, Wayne, I can't thank you enough. We're in our last minute here, and I want to say to our viewers, I hope you found this, as I have, very informative. Hopefully Wayne will come back and speak with us again, and maybe next time we'll have a trustee join us, and that'll add to the conversation also. I thank you for tuning in this evening, and tune in next month. It'll be the first Monday of the month of March from 7 to 8 p.m. If you have any questions about the program, I ask you to take a look at datv.org. You can call the station here, and I thank you again for enjoying, I hope, this evening's program. Good night.